fraud. Repossession isn't about. If you're dealing with any type of repossession, this video is for you, y'all. So if you're dealing with repossession before or after repossession, this is for you, and I need y'all to listen up, like for real. Because a lot of times repossession isn't about any type of mispayments. Okay, it's about lenders and repo agents. What they're doing is they're exploiting fraud. Now I'm gonna break it down. When it comes to securitization and when it comes to IRS violations. So here's the blueprint that they would never teach y'all. Okay, before repossession, you can demand and file any type of UCC-1 filings to put them on notice. Okay. After repossession, you can dispute the trade line. You could force any type of IRS reporting, file complaints, etc. But I'm gonna go break it down and tell y'all what the truth is about these repossessions, because literally when they repossess, look at someone they stole your vehicle. Okay, they stole literally another entity came in and stole your vehicle, and it was a breach of peace because they had no type of authority or authorization to enter into your private property. Okay, because most people think repossession is simple. You miss a payment, you lose your car. But here's the truth: most repossessions are fraud, and here's why. Because the lender usually isn't the holder in due course. Okay, again, the lender is not the servicer is not the holder in due course, meaning they have no legal right to enforce the contract. That's right. They have no legal right to enforce the contract. Okay. So before repossession, here's some things you can guys do. Right. You can demand proof of standing. Okay. You can demand the chain of title. Okay. You can even ask for a UCC-3 termination if it was transferred. So guess what? If they cannot prove they are the true creditor, they have no enforceability. They have no enforceability, y'all. We need to stop letting these people just take our car and come in and just say they have rights. They have none, okay? Again, you can do also a cease and desist, whereas what? It's a breach of peace notice, okay? Repo agents have no contract with you. Remember, guys, we are in contract law. You have no type of agreement with these repo agents or these other entities. Also, file a notice of trespass, okay? Because what? That notice of trespass equals what? Liability for breach of peace, okay? Demand judicial process, not any type of private seizure. And do you know they're supposed to take you through arbitration? It's in the contract. You're supposed to go through an arbitration. They just came and stole your car, okay? And if you're going through and it's some type of serious where they're getting ready to take your car right now, guess what y'all can do? You can also file a temporary restraining order in court, okay? Or you can file a arbitration that is in your contract clause. It can freeze any type of repossessions. There you go, y'all. You're dealing with repossessions. There you go, okay? Also, you can leverage the UCC-1 financial statement, right? Because you can file your own lien if you have added any type of value or type of improvement to that vehicle, okay? It clouds their ability to claim superior interest. Especially when dealing with securitization, what type of security interest or superior interest you have? None. Because why? You are the what? You create the asset. You create the promissory note. Your signature, again, going back to constructive trust, no signature, no constructive trust was created. They're acting as trustees and they have a fiduciary duty or an obligation to meet. Okay? But again, we're all operating under presumptions that they can come in and do whatever they want. Okay? So if your note was securitized, which 90% of these contracts are, put them on notice. You can file a 1099-C. You can file a 3949-A. Okay? That reports to the IRS that the lenders, they rarely comply, which becomes evidence against them. Okay? So what do you do after they have repossessed and stole your vehicle? Okay? Now, guess what? You can demand proof of accounting. Okay? And it's another form I'm going to tell y'all guys about. Before you even ask for accounting, you need to fill out that form, let the IRS know, say, hey, they're the trustees, I'm a fiduciary, now I'm going to request for accounting. Now I'm going to request for the chain of what? Title, the lien, and the security agreement. Okay? I need proof of any type of sale. Okay, so if they can't show this, the repo is unlawful. If they cannot show proof of commercially reasonable sale, the repo is unlawful. Okay, now you need to dispute this with the credit reporting agencies because they must show accurate balance, the date of sale, and a notice of repo, which a lot of times people don't even get. Okay, so if there's no 1099-C, guess what? Then the charge off is inaccurate. So if you have any repossession on your vehicle and they didn't send you a 1099-C, it's inaccurate. You were supposed to get a copy. Okay, so the IRS reporting that 1099-A requires when a property is repossessed. That's right. When that property is repossessed, you need to let the lender know that say, hey, they've already gotten their asset back. They shouldn't be double reporting, telling the IRS one thing, now you're telling me another thing. Okay? So they also require, again, a 1099-C is required if the debt has been canceled or has been charged off. Okay? If not, guess what y'all need to do? File that 3949A, okay, for yourself, because that puts the IRS on their back. Okay? That puts the IRS on their back. Demand proof of auction that it was commercially reasonable. You can force any type of disclosures of proceeds, fees, or attorney costs. Okay, most lenders, they cannot prove this, y'all. Okay, so here's some of the dark secrets, right? So again, due holder in course is the problem. We stated that earlier. They have no type of enforceability rights when they're not even due holder in course because they already signed it to a special purpose vehicle. Okay, which is a trust. Okay, your note, again, was securitized and sold into a trust, which means the lender you deal with often doesn't own the note. No standing, no right to enforce. Okay, repo agents, they are trespassers. Okay, they have no agreement with you. Okay, so if they step on your private property after you gave them notice, that is a breach of peace and liability. Okay, now, that's what you can do before and after any type of repossessions, okay? That is what you can do. So the next time a lender, repo, or an agent comes after you, remember, if they cannot prove standing, you have no rights. They have no rights, okay? If no 1099-C was issued, it's fraud, okay? It's breach of peace, and you can sue. So guess what, y'all? Repossession is about missing no payment. It's about them exploiting fraud, securitization, and tax lien hold. Okay, loophole, excuse me. So learn the law, flip the script, and do not let them play with y'all. They literally